Guten Tag, meine Damen und Herren. Wir begrüßen Sie alle sehr
Ladies and gentlemen, welcome to today's first Basel Conference on the Judiciary on the topic of the separation of powers and the independence of judges. My co-host is Dr. Thomas Stadelmann, who is a federal judge at the Federal Supreme Court. He was awarded an honorary doctorate from the law faculty at the University of Basel for his great international commitment for the protection and strengthening of judicial independence in Europe. With this conference, our Basel Law faculty wants to make a clear signal with that and with our conference and encourage particularly the scientific community to commit themselves to the independence of the judiciary, the separation of powers, and the rule of law. The co-organizer of today's conference is the Swiss Institute for the Judiciary, and it is supported by the European Association of Judges. Its members are provided with a French and an English simultaneous interpretation. It is great to see that there are around 400 participants. Our conference will be recorded and you can watch it afterwards and pass them on to other interested parties. If you have any questions for the speakers, or if you would like to participate in the discussion, you can do that through our electronic chat. Here you can ask your questions in written form, and we will then include your questions and contributions in the panel discussion. The fact that so many of you join us here today confirms how important independence and impartiality of the judiciary are, not only in cultures far away, but recently in Europe as well, unfortunately. This has become a very topical issue because even here, independence and impartiality of justice don't seem to be self-evident anymore. Newest examples for this development, and we're going to hear about them this afternoon, are in particular the EU member states, Poland and Hungary, but Bulgaria and Romania too, and the member states of the Council of Europe and signatory states of the ECHR, Russia and Turkey. This is sad because it was in Europe that the basis of the separation of powers was developed over 250 years ago by Montesquieu. And since then, it has been transferred into a complex multi-layer system of vertical and horizontal checks and balances. And it has since been developed further.
Abgesichert und gestärkt werden dieser
The rule of law in Europe is secured and strengthened by the two European institutional courts. And what we do here has an influence all over the world. Our two constitutional courts are the European Court for Human Rights and the European Court of Justice of the European Union in Luxembourg. They compete with each other to a certain degree and complement each other at the same time. And of course, the national constitutional courts are also part of this partnership. By the separation of power between the executive, the legislative, and judicative branch, we can generally we can generally make sure that there is no misuse of power and corruption. And an independent judiciary ensures a high legal quality and legal certainty, and that people trust the law and believe in legal equality, legal security, and equality in the society in general. With your participation in today's conference, you as participants, you are honored as it honors you as participants, but it also honors our successful efforts to attract renowned experts that you all know. They are going to talk about the theoretical, dogmatical, but also the practical parts and questions around this topic. They will make a critical analysis and compare the different law structures there are. I think that since you are an expert audience, our speakers are very well known to you. So we are not going to introduce them with their extensive curriculum vitae. This is going to save us time for the speeches of 20 minutes. And we have a first European part and then a second Swiss part. And after those two parts, we will have two panel discussions, which will take about 40 or 45 minutes. So we kindly ask all the speakers to keep their time precisely and to stay within the limits of these 20 minutes. So let me introduce to you our first speaker, Mr. Professor Voskuhle from the University of Freiburg in Breisgau, ex-long-term president of the German Federal Constitutional Court in Karlsruhe. The title of his speech is Europe Task Role and Influence of the CJEU in Safeguarding Judicial Independence. Mr. Voskuhle, the floor is yours.
Sehr geehrter Herr Breitenmoser, meine sehr verehrten Damen
Mr.
und
Breitenmoser, ladies and gentlemen, let me first thank you for your attention. I would like to give my talk on the legislation of the ECJ, starting with the constitutional crisis in Hungary and Poland. Article 7 of the Treaty on European Union on sanction proceedings is the article to resort to when dealing with the systemic deficits of the rule of law. But this has proven to be a blunt sword because in order to ascertain that a member state committed a serious and persistent breach of the values set out in this article, we need a unanimous vote in the European Council. These proceedings have been initiated under Article 7, TEU, but a determination is yet to be made. The Commission's proposal whereby member states that fail to comply with rule of law principles can be penalized with monetary penalties. This is called the rule of law mechanism. The European Commission, the proposal for regulation of the European Parliament and of the Council on the protection of the Union budget in the event of general shortcomings in relation to the rule of law in the member states. This has been adopted, but this has been watered down. It is a mechanism that is mutated into a kind of anti-corruption mechanism. Poland and Hungary intend to file an action for annulment against the regulation of the ECJ in the event of such a measure, but according to the decision of the European Council, the decision to activate the mechanism must be taken, and only then can it be included in the guidelines. Against this background, the ECJ has already become active in the past and has used a series of proceedings to grant itself control access according to EU law to check judicial independence at the member state level. The focus is on Article 2 TEU and the promise of the Union of Values to uphold the rule of law. In 2012, in Arman versus Bogdandi, it has been rightly noted that many thought this was almost legal science fiction to activate Article 2 TEU in judicial proceedings. But as in Jules Verne, utopia has quickly become reality. But let's take a closer look. I want to explain the ECJ legislation in 3 phases. The first phase is a prelude, so to speak. I want to talk about the infringement procedure. This was based on a decision taken in Hungary to reduce the retirement ages of judges, prosecutors, and notaries. It declares that by adopting national legislation for judges, public prosecutors, and notaries, this will result in a difference in treatment on grounds of age. In fact, no dogmatic ground or no new dogmatic ground was broken here. Anti-discrimination jurisprudence has always been progressive and not very competence sensitive. But this ruling didn't have a lot of impact, a major impact, because in the wake of the infringement proceedings, the Hungarian government passed a discrimination-neutral law that offered judges who had retired early, they were offered a lucrative compensation as an alternative to their removal. And most of those affected opted for this compensation. Then I'd like to talk about another case, the suspension of European arrest warrants due to unacceptable detention conditions in Hungary and Romania. The ECJ reversed or made the principle of mutual trust more relative. And the execution of a European arrest warrant can be suspended for 2 reasons or 2 conditions. First, objective, reliable, accurate, and duly updated information on the conditions of the detention in the member state must demonstrate the existence of systemic or general deficiencies affecting specific categories of persons or specific detention facilities. Secondly, there must be serious grounds supported by the facts for believing that the person concerned will also be exposed to the risk of inhumane or degrading treatment. With this decision, the ECJ reacted to a decision of the Federal Constitutional Court on the European arrest warrant dating December 15, 2015. Until this decision, it had considered the principle of mutual trust in this area to be practically irrefutable. But important impetus was given by several decisions of the ECTHR on inhumane conditions of detention. But neither the Federal Constitutional Court nor the ECJ could or wanted to ignore these rulings permanently. Now, this brings to the second major phase, and this was almost a drumbeat. This refers to the ruling of the 27th of February 2018, taken by the ACJP, the Portuguese Association of Judges. There's hardly a decision of the ECJ that has been described as groundbreaking, far-reaching, and spectacular. And Leonards even compares it with Van Gent on Loos and Costa ENL. But the subject at hand is actually quite easy to structure. The members of the Portuguese Court of Audits, or the members' salary was actually reduced. But the actual fact was straightforward. In response to the sovereign debt crisis and in connection with the Union Financial Assistance Program, the salaries of the members of the Portuguese Court of Finance were also reduced by a certain percentage. But it was spectacular because this way was quite dogmatic. The ECJ links Article 19, subparagraph 2 TU with Article 2 TU and Article 47.2 of the Charter on European Fundamental Rights, and takes from these provisions the obligation of the member states to guarantee legal recourse to national courts and effective legal protection. The prerequisite for effective legal protection, according to Article 47.2 GRC, is an independent and impartial court. But the concept of independence presupposes, amongst other things, that the body in question exercises its judicial functions in complete autonomy without being hierarchically linked to or subordinate to anybody and without receiving orders or instructions from anybody, and that is thus protected from outside intervention or pressure that could jeopardize the independence of the judges in this body. But what was that spectacular? Well, I refer to the articles that say that all member states need to make sure that there is legal recourse so that there is legal certainty in the European Union. This is a general supervisory norm for the European Union. But the positive values of this article has become a structured savings clause, basically. So Article 51(2) needs to be discussed as well. And this leads to a situation where all courts of a member state are subject to these norms and standards. So it is a systematic monitoring of the rule of law, even though it is supposed to be about breaches. And then we have the Article 49 of the TFEU, checking the legitimacy of a trial. But this decision leads to a material checking of the system. And this is a danger for the equality in the federal structure. And this legislation has been made more concrete in many rulings and decisions. We have the preliminary ruling procedure. I would like to point to the procedure LM. It defined the potential reasons why a European arrest warrant could be suspended. It also defines the reform of the judiciary in Poland and the infringements in Hungary. So the basic principle of mutual trust says that the criminal courts need to abide by certain requirements, of course. For instance, there need to be independent and impartial. If a person affected says that or proves that there are systemic deficits in a given member state's legislation that might interfere with judges, the judiciary, or infringes their independence, then the authority can suspend a warrant according to a two-tiered process. There were other cases, like the one where Spanish judges' salaries are reduced, or the composition of Polish courts and the infringement of an independent disciplinary proceeding in the disciplinary chamber, or the changes in the procedure where members of a certain judicial committee were nominated, also in Poland, and the decision's legal protection. The ECJ defined a principle and these things can be read about in the different articles. It is incompatible for the system if judges still get a salary, but the authority needs to check. It was made clear with the proceedings in Poland that they did not per se question the independence of the courts, but the affected courts needed to check the independence. The rules to nominate and appoint judges need to make clear that the judges to be appointed have to be independent and impartial, and the respective court or courts need to see into that. There were two commissions, two proceedings initiated by the Commission on infringement proceedings. The ECJ saw an infringement with judges' independence, but there was a specific focus on the modality of the prolonging of the term of office. This is in the president's discretion, the president of the different member states, but there is a prerequisite for expanding the term of office and its modalities. They need to make sure that they do not infringe on the judges' impartiality and independence. They must not be subject to external interference. There are certain criteria that one needs to observe when deciding to expand a judge's term of office. But the system in place needs to make sure that judges are not subject to external interference. In Poland, judges, there is a rule for the judges' term of office. It's linked to retirement age. So this infringement proceeding is much more effective for monitoring the rule of law in a given state. The burden of control lies with the court. The ECJ's requirement for a systemic analysis in the different member states can overtax certain member states. And there is a danger of repressions in member states coming from the supervisory body or authority. Infringement procedures can also entail the threat to impose fines. The ECJ has its own access to control, and the ECJ has expanded this control, and that was rather dogmatic. The capabilities have been expanded. Article 47 of the infringement proceeding is to no avail, and there's also a lack of other effective control mechanisms, and they need to be alleviated. The costs of this, I call it judicialization, can be quite high in the medium or long term. Article 19, 1, 2, together with Article 2 of TFEU, the ECJ has full access to all non-harmonized fields. That's what it decided on. When checking the democratic rules in a given member state, this modality can lead to basic conflicts at a quite early point in time, I might assume. There are two decisions that might tell us what Germany could expect. There might be a ruling by the ECJ in line with the Article 6.1 from the framework decision of European arrest warrants. And it's not about the member states' attorney generals or a single decision coming from the Minister of the Judiciary. There is a ruling from LG Lübeck and Zwickau that are also interesting. The president of the Constitutional Court in Wiesbaden also asked whether whether a court is actually independent according to Article 267. Doubts were voiced concerning its own independence vis-à-vis the executive and the legislative. This president said that, well, firstly, the judges are supported by the Ministry of the Judiciary and nominated by it. They have to observe the same rules and regulations as official clerks in Germany. And the Ministry of the Judiciary stipulates what kind of databases or programs they have to work with. And judges are appointed or can be appointed for a given period of time. And the internal organization of courts is also stipulated by the Ministry of the Judiciary. I said it before, this includes databases, programs, and also the Ministry of the Judiciary can also decide on judges' trips and journeys. And this is quite shady. So all these reasons that I just explained are not sufficient to say whether or not it is independent. So the control mechanism I referred to before could have led to a different interpretation. So it remains to be seen what the ECJ says about what was decided in Landfurt. But they had a similar argumentation as the court in Wiesbaden. It is really difficult to come to a comprehensive conclusion.
Spannend und auch natürlich, dass Sie die
Thank you very much,
Zeit.
Mr. Voskuhl. That was very interesting, and thank you for keeping your time. I'm looking forward to the panel discussion afterwards with you and the other speakers. Let's go on to Professor Grimm. He is also a former judge of the Federal Constitutional Court in Karlsruhe. He is talking about Europe, task, role, and influence of the ECTHR. Thank you, Mr. Grimm. The floor is yours. Thank you, Mr. Breitenmoser. Ladies and gentlemen, the European Court for Human Rights, its task is to enforce the requirements of the European Convention on Human Rights in the member states of the European Council. The most important provision for today's conference is Article 6, Paragraph 1 of the European Convention on Human Rights. According to this article, every person is entitled to a hearing by an independent tribunal. Let me say that independence is only one of the provision's requirements. Apart from that, the court must be impartial, established by a law. It must provide a fair trial, and it must make its ruling within a reasonable time. So you see, we don't have this guarantee because of the judges. They exist because of the people who want to file a suit. The ECTHR has no mandate to harmonize or unify the law of the 47 member states of the European Council. It only acts according to a basic standard of the rule of law, contrary to the court we have just heard about, because the European Court of Justice is able to harmonize the legislatures of the member states partially. The rulings of the ECTHR are not binding, though. The judges need to apply the law when it comes to a dispute. And what is important is that the law, that the rulings are made only according to legal criteria and not, for example, economical or political criteria, or let's say religious criteria. What endangers the impartiality and independence of the laws are the other branches, namely the executive and the legislative, like the politics. In a constitutional state, the judiciary should be independent of the legislative and the executive. So the core of the independence of judges is the freedom from instructions. However, around this core, there are also different criteria. They can influence indirectly the judicial independence. So if judicial independence should work and be enforced, we should also have a look at these points. If we have a look at the ECTHR and the Article 6, paragraph 1, since the 1980s, there are four main criteria which are always considered. First, the process of appointing new judges. Second, their terms of office. Third, existing mechanisms to prevent external influence. And a neutral or independent appearance. However, these criteria don't answer all the problems. So in the course of time, other criteria were added. For example, irremovability of the judges, freedom from instructions, secrecy of deliberations, immunity, that decisions are binding, salaries, and to my surprise, they say nothing about the re-election of judges. And only for a short period of time, this century, we also look at the independence within the courts, which is the independence of judges from the panels, the boards within the courts, and so on, and what plays a role for promotion, for example. How these four basic criteria and the other criteria work together, I'm not sure what their relation is. The criteria I just named could just be could just complement the other criteria. Sometimes they are rather about the internal independence of judges, and other criteria about the external independence. What we can see here is that there seems to be no systematic approach, and I think it is difficult to develop a systematic approach since a judge's work differs from case to case.
Das Verfahren der Richterernennung. Und dazu ist
so the largest gateway how the judiciary can be influenced is in the appointment of judges. So when judges when judges are appointed who are an extended arm of the political branch of the legislative or the executive, then we don't have independent judges anymore. But here we come across a difficulty which is larger than the European Union, who has 27 member states. I think the Council of Europe has 47 member states. So we have a great variety of different legislations. So if you just end, what is more, if we just look at member states' legislations, they don't necessarily reflect the state of judicial independence in the respective countries. So we don't really know how it works in practice. We also need the legal cultural background to assess the judicial independence in a country. We do have this option. And we know systems where where the regulations are such that politics could influence the judiciary, but they don't use that possibility. And there are other systems with checks and balances, but still the politics can influence the judiciary. For example, if a certain political party rules a country and is also able to influence the judiciary. Now, the ECTHR says that no system of a Council of Europe member state is actually incompatible with Article 6 of the ECHR. It then refers to the freedom of instructions. And then it says that it doesn't matter how the judges are appointed if they then are free from instructions. But actually, in the appointment of judges, we can influence the process, and afterwards, such instructions aren't necessary anymore because the judges listen to the executive, for example, anyway. And the ECTHR only judges according to the legislature whether the freedom of instruction is upheld. And according to this logic, the snake eventually bites its tail. The Committee of Ministers apparently favors a system of intermediary councils of judges, and many of the former socialist states went over to this system to assign the appointment and promotion of judges to such a body. But that doesn't really solve the question, since we still don't know who is entitled to appoint the members of the body. So the ECTHR doesn't have a clear line here either. There is a different picture when it comes to the time and terms of office. The terms of office are limited by law. So, but there are also legislatures where there are only very short terms of office of judges. The terms of office also play a role when it comes to the question when a judge has to terminate, to leave office. And here we touch upon the question of how judges are exchanged, who follows a retiring judge. So here we don't rely on the legal guarantees, but the legal guarantees are not touched upon if there is no practical implementation. So the so if we need to exchange judges within a court proceeding, this may work, but it needs to be a legal, but there needs to be a legal basis which doesn't exist so far. So the fourth reason is the appearance, whether a court, it doesn't only have to be independent, but the public or the citizens don't have to believe that they are truly independent. And here to make sure whether this criterion is fulfilled, the ECTHR refers to the three above mentioned criteria. And here again, the snake bites its tail. I actually don't have the time to touch upon examples, but I can only give my assessment here. I think that judicial independence depends on many individual factors. Dangers are present on different levels and come from different directions. And if you want to assess the independence of the judiciary in a country, we need to assess all these individual factors. So if we want to ensure that a judiciary is independent, we need to have a look at the practice and not only at the laws. So what we do at the moment is always only looking at individual factors or criteria or rules and regulation, and then we want to exchange or modulate individual factors. But one factor doesn't decide whether a judiciary in a country is independent or not. So if we talk about the appearance of independence, that doesn't say us much. So if we, as I said, want to assess the state of a country's judiciary, we can't only look at the laws. We need to consider the practical implementations. And there are individual judges who say that we must do more in that field. So the task of the ECTHR to ensure an independent judiciary in its member states can be fulfilled based on the options the court has at hand at the moment. So I'm very honored that a person who is a specialist in this field is present here. She is the next speaker, and all the mistakes I made, you can now remedy. Miss Angelica Nusberger.
Thank you so much, Mr. Grimm, for this informative speech. Thank you so much for these valuable insights into the legislation of the Strasbourg-based Court of Justice. And thank you so much for observing your time slot. Thank you so much. And you have already done a very nice segue to our next speaker, Angelica Nusberger. She is a true expert on this field. She was the vice president at the European Court of Human Rights in Strasbourg. And without any further ado, Ms. Nusberger, you have the floor. You will talk about Europe, the role and possible influence of the Venice Commission. Thank you so much, Chair. Thank you so much for having me, ladies and gentlemen. The speakers who came before me had a huge advantage. They could resort to norms and standards to give them a framework. We heard the reference to Article 19 and 2, and we referred to Article 6. of the ECHR. Now, I would like to talk about the field of soft law. And there isn't the standard we could start from. It's rather an opinion of mine or an experience that I have made. Maybe you know what I'm talking about because we were all judges or experts, and we know how hard it is to strike compromise every now and then. Compromise can be a time-consuming thing, and you need to come up with a compromise everyone is willing to sign. One of the most impressive examples was the struggle in the Venice Commission to reach a common understanding of what is to be understood as the European standard for independence of judges. We were 4 rapporteurs in that group: the Russian Constitutional Court President Zorkin, the Italian criminal law professor Nepi Modena, the retired Icelandic Supreme Court Judge Torfason, and myself. So 4 people, all in all. We were asked to issue an opinion on the independence of judges in Europe. The main problem was the split between the Eastern and Western European parts. While the Central and Eastern European countries were trying to build a new judicial system after the fall of communism in 1989, 1990, and the establishment of councils of judges and certain structural organizational arrangements were regarded as best practice for this purpose, while the so-called old democracies argued that, well, they could not accept certain objective and sensitive standards because they did not think it was necessary, and to translate them into systems that have been worked well, because you should never change a running system. Why should you make something new if this has worked well for decades? If a system works well without judicial committees, why should you establish judicial committees, by way of example? Now, the compromise was the following formula. Firstly, there is a variety of different systems for appointing judges in Europe, and there is not one single model that would apply to all countries. Secondly, in older democracies, the executive sometimes has a decisive influence on the appointment of judges. Such systems can work well in practice and allow for an independent judiciary because these powers are limited by legal culture and traditions, and they have evolved over time. However, new democracies have not yet had the chance to develop these traditions that can prevent abuse, and therefore, at least in those countries, explicit constitutional and legal provisions are needed as a safeguard to prevent political abuse in the appointment of judges. So that means the Venice Commission, that should have reached a common norm for everyone, had to use a compromise that works for Eastern and Western European countries. To me, this seems to be an element that, especially for the judiciary in Switzerland and in Germany, is of huge importance, because we're faced with those questions as to why we do not introduce standards and norms that other European countries have been demanding for many years. So this is to serve as an overview of the Venice Commission's work and the compromise from 2010. And against this backdrop, I would like to comment briefly on some cases in which the Venice Commission was called upon to answer questions, and they introduced some kind of constitutional fire brigade that should come to the rescue and extinguish fires if need be. And I would then like to talk about some methodical questions. Well, I said I wanted to provide you with examples. The first example is Albania. The initial situation was as following. There is a high level of dependence and corruption in the judiciary, which is an endemic problem and has been an endemic problem for many, many years. In some cities, judges applying for a certain judgeship had to pay for those vacancies, and it was sometimes a very large sum of money. It was a lot for the judges or the candidates. Now, this situation should stop. They wanted to introduce a vetting procedure that would have to be done for the already appointed judges and the new judges that wanted to be appointed. So not only starting now, but also in hindsight going back 20 or 30 years. And it also entails the disclosure of their financial assets, not just their own, but also their relatives' financial assets. So it should be a comprehensive vetting procedure done by an independent body. So if someone owns an apartment, but they cannot prove what they had earned to afford that apartment, then this was something one should see into. Some of the judges failed this vetting procedure, and in the Supreme Court, basically no one was left there anymore because they failed the vetting procedures. There was only one female court, but her mandate actually had expired, and that was at the Constitutional Court. So judges or new judges couldn't be appointed anymore because the replacement of the Constitutional Court should have been done by a certain formula: 1/3 President, 1/3 Parliament, 1/3 Supreme Court. So again, the Venice Commission was initiated as a constitutional fire brigade, but basically it did not help the courts. It emptied the courts. In this case, the Venice Commission tried to interpret the Constitution so that the Supreme Court and the Constitutional Court were still functioning. But again, this example of the vetting procedure shows that even the best ideas can have very bad consequences, the best intentions basically. Empty courts in Albania would have led to a non-existing judiciary. My second example is from Russia, a new example. The Russian constitution was amended, and these amendments are being checked by the Venice Commission as we speak. These amendments also affect the judiciary in Russia. What is new is that the president of the Russian Federation has the right to nominate courts or to remove courts in the Constitutional Court, in the Supreme Court, different courts, different judges. The initiative can start with the president. The requirement is as such: violation of the honor and dignity of a judge, as well as in other situations established by law, which show that the judge is incapable of continuing to perform their duties. That's the requirement. So you will likely end up with two basic problems: the dependence of the judiciary on the executive. Not only talking about the appointment, I'm talking about the removal of judges if the president believes this should be done. And the requirements are quite vague in general. And it is not a European standard, because a European standard says that the definitions have to be very clear and the conditions need to be very clear why a judge has to lay down their mandate. So again, the Venice Commission was requested, and I believe that these examples alone, also on a constitutional level, these examples show that the tendency goes toward a weakening of the judiciary and a growing dependence of the judiciary on the executive. My third example is Poland. My predecessors, the speaker before me, talked about this before. It was in connection with the ECJ. Reforms came from the Constitutional Court. There were reforms of the Supreme Court and reforms of general legislation. And the Venice Commission has accompanied the entire process and issued clear statements and opinions. There was an opinion in 2020. It was about the prohibition to doubt that a judge appointed by the president is a legitimate judge. A violation of this leads to a disciplinary proceeding, so it was not allowed to voice doubts whether or not an appointed judge is legitimate. This would end up with a new extraordinary chamber of the Supreme Court, but this would lead to a situation where the vetting process lies with the same body. And this body is already in a situation where it cannot decide independently and impartially. So these examples, I believe, show that the Venice Commission is resorted to as a constitutional fire brigade, and these examples also show the dimension of the threat of judicial independence in Europe. So what's the function of the Venice Commission? Well, its mission is to issue concrete opinions on current problems it is presented with, referring to independence of judiciary systems. Besides these very concrete tasks, the Venice Commission also should voice abstract standards or define standards that serves as a skeleton to these clear and clearly defined statements and opinions, like the opinion on the judicial independence from 2020. It completely includes the legislation of the ECTHR. It is copied by the Venice Commission, also legislation from the ECJ and international standards like the UN Basic Principles on the independence of the judiciary and further soft law standards. They all flow together, so the Venice Commission can use it to come up with something that can be seen as a European standard. The method is, of course, problematic because we talk of European standards, but non-European standards assess the statements and different soft law instruments that need to be linked together. So the idea of European standards is, of course, a vague requirement that is evolving. To what extent is the Venice Commission's approach successful? Well, it fills a void. The ECJ, Mr. Fosk said it before, the ECJ is or has become a court deciding on the state's legitimacy. So now the Venice Commission has filled a void. I believe its track record is mixed. In the case of Albania, certain standards have been adopted, and they took the Venice Commission's opinion as an orientation. Sometimes the Venice Commission's success is of medium-term nature because it starts off as soft law and it becomes hard law, so to speak. But Poland, for instance, is not a success for the Venice Commission. Well, I mentioned these three countries, but we're here to talk about Germany and Switzerland. We have similar questions concerning judicial independence. We talked about the Court of Wiesbaden. This court questioned the state of independence in Germany. So we are faced with different challenges in the different European countries. And the big problem is to develop general standards. I believe that there are very well-defined standards For instance, presidents are not allowed to initiate the removal of judges, but certainly we can discuss the appointment procedure of judges. As to the opinions of the Venice Commission and the development of standards, and this is very important to me, this is what the Venice Commission sees it as rule of law checklist. I believe the rule of law checklist is quite helpful because the rule of law, of course, comes with different interpretations, but the checklist consists of, well, different topics: legality, legal certainty, prevention of abuse of power, equality of rights, prohibition of discrimination, and access to the court, and also independence and impartiality. So what does it do, or how does it work? It develops questions for that rule of law checklist. And these questions, or the checklist, is to be seen as the yardstick that one can apply to assess a state's judicial independence. It's 24 questions that are considered central. Regulations on judicial independence, for instance, the appointment and dismissal of judges, their terms of office, reasons for their removal. Is it appointment for life or limited? Reasons for dismissal, I said that before. And of course, also appeal against dismissal. And this is a central point. This boils down to a legal tradition or a legal culture. Whether or not judges are seen as independent and impartial or the opposite, well, this also boils down to whether or not there is a basic trust in a given country. Is the judiciary considered independent by the population? What is public opinion with regard to possible political influence and manipulation in the appointment or promotion of judges, as well as in their decisions in specific cases? These questions are central. And this boils down to what I refer to as a legal culture. Appearance is very important. Disciplinary proceedings can be used as breaks in a certain country. There were different cases like Volkov versus Ukraine or Ramos Nunes versus Portugal. The ECTHR had different decisions. Of course, there are critical questions when measuring the judicial independence in different European countries. We should apply an equal yardstick. And it remains a challenge to come up with a comprehensive shared approach. Thank you so much, Ms. Nusberger. Thank you for this interesting talk. Thank you for your information and explanations. It was very enlightening. Thank you so much. And we have time for a small panel discussion, which I am about to start now.
We have not received any questions from the audience yet. So we invite all the participants to submit their questions. It was something you might have not quite understood, or something you would like to contribute from your practice, from your work. So we welcome every contribution. Just submit them in the chat or in the Q&A section. So as long as we don't have questions from the audience, I start with a question from my side. So my first question is for all the three of you. Ms. Nusberger, you said that the Venice Commission, as a firefighting unit for the rule of law, tries to bring in abstract suggestions. You also try to find compromises between all the new democracies. So my question is, it comes to a surprise to me when I talk to colleagues in Switzerland and Europe that the efforts of the CJEU and of the ECTHR are not known. For example, how if Mr. Grimm said that the main question is how judges are appointed, we see that in Strasbourg and in Luxembourg lately there have been spectacular changes to ensure the quality and competence of the judges of these highest courts, because this has an influence all over Europe and the member states of the Council of Europe. For example, since the Treaty of Lisbon, we have Article 255 on how the European Union works. We have the 255 committee, and you, Mr. Voskuhle, are not only a member of this committee, but the president. So we have a new example with this body who has a large influence with the expert opinions it publishes. So now's my first question. Here's my first question. Can you tell us something about your work in this field? And maybe as a second question, can you tell us something about the ECTHR in Strasbourg? We realized that it is subject to criticism, which 20 years ago would have been impossible. And we also realized that in the last few years, the judges didn't have the same quality and personality and charisma as former judges. Maybe this has also something to do with the new member states of the European Union. But here we realized that we need a special committee to appoint judges and maybe to refute or to comment the applications which are handed in by member states, so that the appointment of judges is done or prepared by an expert committee. So Ms. Nusberger, when you deal with newer democracies, have you ever referred to these new developments in Strasbourg and Luxembourg? Because I realized that in Switzerland, no one knows these new rulings and these new regulations. We have a judiciary commission here in Switzerland, for example. We're going to hear about that, but they didn't really do their homework so far. We now talk about constitutional reforms, and with that, we could think about the reform of these judiciary expert commissions in a way they already exist in Luxembourg and Strasbourg. So that's a question for all of you, but maybe you start, Ms. Nusberger. Can you tell us some examples from Strasbourg and Luxembourg and how you use them in the Venice Commission? Yes, that's a very important point. The appointment of judges who then influence the jurisdiction directly and indirectly. That's a large problem. For example, my mandate ended a year ago, and one of my colleagues has ended 2 years ago, but my colleague still works as a judge because we still didn't receive applications for to replace us. because the reason is that the member states don't cooperate with us with the applications. Some of the lists have been blocked because these bodies, these special committees, judiciary committees, said that the candidates don't meet the requirements. They refuted the list from Turkey, for example, from Azerbaijan and different countries. So there were not many colleagues who left the courts and were replaced immediately. With basically all the replacements, we had problems that the standards didn't that the standards were met. For example, Germany, the court told Germany that they didn't have a transparent election process for the candidates. Now that's a problem. If judges refute or tell countries that their processes are of the appointment of judges are unconstitutional, but then they themselves were elected in an unconstitutional way. Now, the ECTHR at the ECTHR, there were a lot of former judges from the CJEU. They are very competent, of course, but the rulings of the ECTHR are not binding. So let me say one more sentence. At the CJEU, what is critical is the option of being re-elected. I think this is incompatible with everything we ask for in the name of the Venice Commission. We say that even temporary judges can be a problem, and if we have the possibility of judges being re-elected all the time, this is a problem we should think over. This is also what Poland said. Well, you have the same system, and then we said that we are structurally completely different as a European court, but actually, that is not true. Courts are courts, and the structure of courts is the same everywhere. Mr. Voskuhl, would you like to answer that? Yes, please. I'm sorry, I have to correct you. I'm not the president of the 255 Commission. I've just been a member of that committee for the longest time. This committee has a very important task. We are 7 people. And it's just difficult to find appropriate candidates in all the member states to work as judges in our established system. These qualifications are defined in our laws. They require a certain expertise. At the CJEU, that means that you need to be able to speak French and you need to be apt in European law. And we often have the problem that questions are asked to the candidates. Our commission assesses the candidates. And for example, we asked, can you tell us 3 important rulings of the CJEU from the last 10 years, and we don't get an answer. This is sad, of course, but this is a situation we come across very often. And it's not only candidates from new democracies, which we cannot accept. It's also, for example, candidates from Austria. Our requirements are very high, of course, and the candidates need expertise in international law, which cannot be taken for granted with judges from smaller countries, for example. We haven't had any situation yet where our recommendation wasn't taken into consideration. The court always respected our assessment, and I think that if the court wouldn't listen to us as a commission, we, as members of the Commission, would leave it because we think that our decisions should be binding. Now, we also see a positive development. The appointment of candidates is more systematic in ever more countries. There is more transparency and more constitutionality in the process of the appointment of judges. So I think we could go towards such a solution to develop mutual standards. And these efforts, and we are pleased to see that the countries make these efforts. And when we see that a candidate has been appointed in a country where this candidate had to go through a systematic process, this lets us trust in that candidate. So what do you think about people, or what is there are also people who apply for the highest office in court who are haven't been judges in their countries, but for example, state secretaries. They have, for example, successfully negotiated treaties for their small country, but they have no experience as judges. Do we want this kind of person to be judges, people to be judges at the CJEU or not? This is not something the Commission can decide. What we say is that people who want to be judges, they need to have 20 years of experience in a high-ranking post or profession, but not necessarily as a judge. So people who have worked as state secretary for 10 years, they have a completely different mentality and understanding of the law than people who have worked as judges. They have a different fundamental understanding of courts and the proceedings at the court. I think that this is something we need to discuss, and we need to establish a common understanding on what does a judge have to be like, and particularly on a European level. We need to ask ourselves, what kind of judges do we want? We need to develop criteria, which is of course difficult. Because even if you try to define independence and what the implementations of independence concretely are, so I think that's quite a complex question. Thank you very much, Mr. Voskuhle. Mr. Grimm, how would you answer these questions? And Ms. Nusberger and Mr. Voskuhle already gave you some keywords you could talk about. I actually don't have much to contribute because I was a member of an international court. I agree with Ms. Nusberger that the re-election of judges is a potential source of danger. So if a judge, for example, doesn't meet the expectations, you can just get rid of him in quite a short amount of time. Maybe I just didn't come across such cases, or I didn't see them, but I think that we need to pay attention to this fact. In the CJEU, there is a re-election process. And I think that they don't want to hear any different opinion, because then it can easily be attacked. Let me take the opportunity to touch upon another topic we need to discuss, I think. an international court needs to treat all its member states equally and not differentiate between the good and the bad. So is this possible at all if the judiciaries in all the countries aren't equal? So if I treat everybody equally, but they are not the same, then I maybe strengthen these inequalities.
Ich denke, ein guter Punkt. Die Frage wäre noch.
That's a valuable point. Thank you very much. Now we talked about these two courts, the CGEU and ECTHR, and I already touched upon the idea that there could be a certain loss of trust, which is why they needed to implement a judiciary committee. But on the other hand, we have the Lisbon Treaty, where there is also an improvement when it comes to the appointment of judges. Can you also say something about Karlsruhe and the German Federal Constitutional Court? Because that's also a court which is widely known and respected. Its representatives are respected beyond the borders of Germany. Here in Switzerland, we also read the rulings of Karlsruhe with great interest. So maybe something works better in Karlsruhe or in Germany than in other countries or on the level of the EU. So maybe you can touch upon that question as well, particularly when it comes to the appointment of judges in Karlsruhe. I think we can boast something about that, Mr. Grimm and I.
Einmal den großen Vorteil in dem Verfahren, dass wir eine Zweidrittelmehrheit brauchen.
So what is an advantage in our process is that we need a 2/3 majority in the parliament. So we need to elect candidates which are likable by all the parties. So let's say people with extreme positions don't stand a chance to be elected as a judge. So this is one advantage. And the second important advantage, I only understood when I started to be a member of the court. So why is Karlsruhe not yet involved in politics? Because being a judge there is a very lucrative office. So why don't the parties put judges into our highest court? So why is every judge in Karlsruhe highly qualified? Today, this is Mr. Habert, Mr. Müller. They are outstanding jurists, outstanding lawyers. The reason is that if you are a member of the court in Karlsruhe, you need to work in Karlsruhe. So if you don't know anything about law, you have to work alone there. People will know directly that you know anything about it, because if there is a ruling, if something is in question, people will ask, "Don't you know the ruling of this and this year and this section?" And if people don't know it, the audience immediately knows that they're not qualified. So we pass the rulings alone. We do the consultations alone. So so therefore the offices of the judges are unattractive to people who just want to have a prestigious office, because they actually need to do the judiciary work. Second, there is a pressure in the court to be independent and to not rule in a political way.
Ich sage es mal ganz vorsichtig, etwas leistungsschwächer sind als andere, sich aber trotzdem sehr
people who do not perform as well as others are very diligent, which also leads to the fact that quality is high. But we also have our problems in Karlsruhe, and one of them is always also, so what we need, what our problem is that we don't have a representative cast of the board of judges. For example, we needed to replace a judge, and the replacement judge needed to be from the east of the country, and we decided to take a candidate which was not the favorite, but she was from the east of the country, from eastern Germany. So what about the representation of other bodies? What about the churches? If we don't talk only about women and men and East and West, but also about churches, other groups, I think that the courts should independently pass their verdicts and rulings, and they shouldn't be just boards which represent all the population. So I think that this is a problem and a danger that our highest courts, that the quality of our highest courts degenerates, because we cannot appoint the most capable people to these posts, but that we always need to consider representation, which means that the quality degenerates. And I think that's a difficult problem.
Thomas, would you like to ask a question? No, an administrational comment. If you have any questions, do not use the chat function, use the F&A function. And another remark. Anne Sanders is with us. And during the second part of today's conference, well, she will give her lecture, but she has already joined the group. Sanders is professor at the University of Bielefeld. She has worked with the CCGA, the Consultative Council of European Judges, and I wanted to welcome her. We talked about different courts, the lower courts, the highest Supreme Courts, but during the three previous talks, we talked about their roles. The Venice Commission has a consulting role. It is to give advice, but it depends on the state's willingness to do good. Mr. Voskuhle, you said that the ECJ is taking a look at the systemic framework, that it has given itself the competence, and Mr. Grimm, you said that the ECTHR is not yet doing this. Now, I would like to ask you, all the four of you, what would have to happen for the ECTHR to stop that? Why am I asking this? I'm under the impression, well, you can tell yes or no, but I'm under the impression that it works better in the European Union because it has certain standards. And outside of the European Union, Russia, Turkey, it doesn't work at all. Who would like to start? Who can answer this question? Well, I would like to start. Let's take a look at the scale, national state and European Union. It's being changed quantitatively. It's a single state, and then we have 47 on the level of the Council of Europe. So there are always different levels, and it is, of course, much more difficult for 47 states to not only compromise on concrete measures or assess the situation, to first assess it on a member-specific, country-specific level, and then extrapolate it to a comprehensive solution. It is, of course, difficult, and one needs to bear this in mind, but still, they need to tackle this. You might not be able to solve the problem on the highest level. It is a step-by-step approach, level by level. And it's difficult to systemize it. But let's say we were able to assess or embed a context or a situation with 7 or 8 variables into a joint context. That would be great. That would be quite some progress. Ms. Nusberger has an internal view. I have an external view, so maybe she could be the right person, or she is the right person to answer that question. Of course. First, I would like to explain how this has grown in Strasbourg. There are different chambers, and it has become an urgent problem. The ECTHR and the ECJ don't have a good initial instrument. Why? Well, I mean, we heard about that at Mr. Voskuhle's presentation. Article 19 wasn't meant like that, but they said, okay, we don't have an instrument that is better than Article 19. And it comes with a dogmatic problem, to say the least. The ECTHR also has a dogmatic problem because it deals with cases like these in a twofold way, and sometimes it works quite well in terms of protection. The citizen says, I stand before an independent court, but how can we prove that? And then we end up with all these criteria that you were referring to. And it's very difficult to explain all that. And then there are exceptions, the Turkish military courts, you name it. And we try to end up with objective criteria. And then there are deficits in courts. And we see that once judges are removed. And if this situation is brought to court, then this case ends up with judges. So you don't have a subjective right to independence. It is an objective right. And the court in Strasbourg really tried to construct it around the corners, so to speak, with Buckhart, for instance, where the president was not, his term of office was not expanded. It was the president at the Hungarian Supreme Court. And he started working on the freedom of opinion. That was the initial point. The Article 6 topic was a topic on the fringes, and that was the big problem. The ECTHR tries to control these situations via Article 8. And then we have the Polish judges trying to fight this, and they're being sanctioned. They say they are removed. It is an interference with their private life. But we do not have the occupational freedom. And these cases will make us a court, the Supreme Court of labor termination. So it's a problem to be able to use that and take it to the Court of Human Rights with a link to labor and employment. So the basic construction is difficult. If I may chime in, let me ask the following question. In the beginning of the ECTHR, we had state complaints and then individual complaints. And we have seen over time that it does not work well because the states see another state's complaint as an attack. So we have the High Commissioner for Human Rights, or maybe a body like this. They need to be able to file a complaint when it is about a systemic problem. Ms. Sanders, would you like to say something? Sure. What Ms. Nusberger just said is central. The courts are institutions
da sind und nicht dazu da sind, institutionelle Garantien durchzusetzen. Das ist eigentlich etwas, was Gerichten eigentlich nicht zukommt, was man ihnen zunehmend zuweist, sowohl national, zum Beispiel in Bezug auf ökologische Fragen, nicht sozusagen der Individualanspruch auf den Klimaschutz und solche Sachen und eben international institutioneller Anspruch auf Rechtsstaatlichkeit. Und das ist eine sehr spannende Entwicklung und da müssen wir uns natürlich auch bewusst sein, dass das auch ihre Risiken birgt gewissermaßen. Insofern wäre es eigentlich sinnvoller, sich zu überlegen, wäre nicht sowas wie der Hochkommissar Staatenbeschwerden, sowas eigentlich die besseren Ausgangspunkte und auch Institutionen, die das, was Herr Grimm eben auch als kultureller Frage, Rechtsstaatskultur, Kultur der Unabhängigkeit, habe ich das mal genannt, bezeichnet, dass man da größere Blicke nehmen könnte, eben sagen könnte, in welchem Kontext steht das alles. Beim EGMR war mein Eindruck, wenn ich mit ihm im Zusammenhang mit dem CCJE zu tun hatte, in Diskussionsrunden durchaus der Eindruck, dass viele der Richter sehr, sehr aktiv darüber nachdenken, wie man zum Beispiel Artikel 6 individueller auslegen kann. Aber die Frage ist natürlich wirklich, wollen wir das und ist das der richtige Weg dieser Gerichte? Und entspricht das dann unserem Richterbild, um darauf noch zurückzukommen, dass der Richter im Grunde eigentlich nicht auf den Einzelfall schaut, sondern notwendigerweise auf die institutionellen Zusammenhänge.
Ja, hier, ja, Herr Voskuhle, bitte sehr.
Ja, also ich möchte das sehr unterstreichen, was Frau Sanders gesagt hat.
I would like to highlight what Ms. Sanders just said. We all want to help. We're observing what's happening in Hungary and Poland, but their options are limited. Let's take a look at the ECJ situation. We have two trials. Now, single judges, maybe they're even affected themselves, they need to try to develop international standards and present them in their own state. This is very difficult. And sometimes they have to fear sanctions, maybe within the framework of an arrest warrant. If you expect of the court to rightly assess the situation in another country with all its complexities, then this is really what an institution can do. It's very, very difficult. And a procedure of monitoring a state's rule of law is not the right procedure. The Commission has more options, more opportunities, but we need a very detailed analysis of the links and connections, and it leads to a situation where the judicial penetration isn't very precise. It's an overall analysis, open to interpretation. Maybe this monitoring mechanism to supervise the rule of law is good. the Article 7 proceeding is the right one. You would have to have different majorities, or maybe you could think of different institutions. Ms. Sanders referred to that. So you can exert political pressure, and you can discuss these issues from a political perspective. The infringement proceeding could be decoupled from financial means, but maybe this is much more helpful to have this link than with sorting to the judiciary. But if you couple it to a subjective claim of an individual, it brings us to a situation where political questions need to be decided upon by judges, and this will lead to a problem of acceptance. Mr. Grimm? I second that strongly. What we are seeing right now in connection with the ECJ's jurisdiction is that it gets praise, but the European Union doesn't have effective tools to make sure that the member states observe their own rules and regulations, and then they open a door and they are applauded. It's not doable in institutions, but it's now doable in courts. And it's not only a question of formality. We have the separation of powers. That's also the title of today's conference. We have the separation of powers for a reason. The three powers are separated. And I believe in the long term, the damage is harsh. It's quite big. Well, time is of the essence. It's 5 to 3. And there are so many questions coming in. I don't know what question to pick. I do not want to decide which question to take. It would be done arbitrarily. But there are questions or my question to you, that if you could make some general remarks. There is a discrimination between ECJ and the court in Strasbourg. It only has a fraction of the financial means the ECJ has. Ms. Nusberger referred to a case in Albania. What about their budget-related financial structures? Shouldn't they play a role so that they can see to it that judges are independent? That's one thing, budget, financial links, and concrete interference by the executive. I'm sure you know what Lucius Willhaber told us, the former president of the court in Strasbourg. He told us about the ambassadors that paid him a visit, and they were trying to exert influence. So that's an example of concrete interference by the executive. Another block of questions could be about standards for re-election, if there is a possibility of re-election, like we have in Switzerland. What could be a standard developed by Strasbourg or Luxembourg? And in what way could the Commission's opinions be included? And a last question that affects us a lot in Switzerland is a question pertaining to political party affiliation. political parties have a recruitment mandate, basically, but it comes with a recruitment responsibility. When we were enrolled at university, it was different, and things have evolved, of course. 7% of the Swiss population is enrolled in a political party nowadays. Maybe I start with Ms. Nusberger, maybe some final words, and you can pick the question now. Maybe you can start. We do not have a lot of time left, I'm afraid. So maybe one phrase per question. As to the recruitment process in Switzerland, well, the European understanding is different. I've always known the reactions when I explained the recruitment processes to the Constitutional Court in Karlsruhe. They told us, no, we had never been a member of a political party, so it's the opposite, basically. And in the East European countries, it's different too, and we can understand where their understanding comes from. As to financial means, yeah, the court in Strasbourg is poor, same for the court in Luxembourg. And I don't believe that they will receive more financial means. The countries to criticize that are the ones that do not want to invest more. So I bow my head to the registry. They have only some means, but they make the most of it. As to the question concerning to re-election and standards, re-election shouldn't be possible. It was abolished at the ECTHR for this exact reason. And, well, as to the last point, concrete interference by the executive. I have never seen that, but let me say the following. There is an indirect interference, which is quite problematic, and we have to deal with that. Let me take Switzerland as an example. You know that there was a referendum in Switzerland, I believe it was 2 years ago. And it would have led to a situation where Switzerland dropped out of the ECTHR. It was about the last word being with the judge. And if you make rulings, does that mean that the state affected can step on the brake? And the judges who basically read the paper and they know what's at stake, they could, I say they could be pressurized. They could be put under pressure. But it's much more, well, the indirect interference is much more central.
Hinter der Frage der Parteilichkeit.
When it comes to the question of the membership of parties, we need to answer a larger question. Judges are part of the state power, and in a democracy, they need a democratic legitimation. And if they're not democratically legitimized by a people's votes, which I do not support, let's have a look at the US, and you understand what I mean. You need to have money to finance your campaign, your pre-election campaign, and so on. So if you don't want to legitimize yourself by the people, which I don't think is necessarily good for the office of a judge, then we need to take the legitimation for somewhere else. And we can then almost only legitimize ourselves by people who have themselves been legitimized by the people, which is the parliament. So we can't really get around the political parties. And even if we establish intermediary bodies which are impartial by appearance, they are not so impartial at a closer look. So I think that we just need to deal with that people belong to a party, or judges belong to parties. I don't think that it is helpful if we forbid the judges to be part of a party, because it doesn't necessarily mean that they represent certain values and that they judge according and in alignment with these values. I think that this is most important, that that the party values don't influence the judges' rulings. Now, I think we get back to the legal culture of a country. The Federal Constitutional Court is legitimized by the legislative, and the 2/3 majority in Germany led to the fact so far that there is in total a high neutrality of the Judiciary Board in Karlsruhe. And I don't know why it's not different, because usually if we have a supermajority that elect a body, it is usually the case that parties tell each other, you accept my candidate and I accept your candidate. But that was never the case. The political parties agreed upon the candidates. And they often use the means of a veto. But the public doesn't know that, because these sessions are held behind closed doors. Well, I'm not sure whether we should open the doors and whether that would lead to better or rather worse results. Thank you very much, Mr. Grimm. Mr. Voskuhle, you have the floor. Thank you very much. Mr. Grimm said everything I wanted to say about party membership, so I don't have to repeat this. Thank you very much, Mr. Grimm, that you said it so clearly. So we can't avoid the parties, and that is not bad, because they are also a form of democratic legitimization. What I consider central is that judges cannot be re-elected. I second Ms. Nusberger's opinion there. I think that's a very difficult situation, because for the person, this is about her or his status, about the social standing. They depend from, so they want to be re-elected, and then they do what is necessary. So if you imagine that somebody from Romania, where a judge earns about 1,000 euros, and in Strasbourg you earn 22,000 without taxes, it is clear that you want to continue that mandate, and I think we need to change the system here. We also need to give another thing a thought. When it comes to internal positions like the president, it means that if we do official elections there internally, then you need to do a pre-election campaign and so on, and you have to form a group of supporting judges. So I don't think that this is a very healthy procedure. So we need to have a closer look at our and the international courts and make sure that they are financially well off. They have to be financially secured, and the judges too. If a judge, terminates his or her term in office, they need to have the option of receiving a pension, because otherwise he will slide into a new dependence. And I think that is quite problematic at the two international courts we are talking about. So a person who stops working as a judge in one of the courts has nothing when he terminates his term in office and needs to find something new how to earn money. So we worked out some solutions in our commission. And we underline that the salaries of judges shouldn't go beyond a certain point and that they are essential to our proceedings. Last thing I would like to say when it comes to interference, when we talk about actual court proceedings, then courts are more resilient than we might think. It's the indirect interference at the beginning and in the end, which are the point of danger but we never get phone calls where people say, could you please pass your ruling in this or that way? I think that this happens less often than you would say. When I was a judge, I never came across such a situation and nobody ever told me such a story. The problems are at the beginning. Who gets access to the court? And at the end, can I stay? What will I do afterwards? And so on. So I think this is where we need to put our focus. Also, when it goes about when we talk about freedom of instructions, then we don't really have this problem in Germany because there will always be a political fuss about such a case, and that would be dangerous for example, a politician who wants to influence a judge. I don't think that this is where our problem actually is. There are countries which might deal with that problem, but I don't think that we should focus on that in our discussion at the moment. Thank you very much. Thank you very much, Mr. Voskuhle. We have still some time left for Ms. Sanders. So we can just grab a coffee afterwards and take it back and drink it in front of the screen. So we do have a bit of time for Mrs. Sanders. So, what I consider important is that there should be no re-election. I think that is a central point. Also for the prestige of the Federal Constitutional Court. I think that is central to the Federal Constitutional Court in Germany, that there is no re-election and that the judges always know what they will do afterwards. So they can pass their rulings freely and independently. Financing is another point I would like to touch upon. If we want an independent judiciary, we need to finance them well, because if the buildings degenerate, if a judge doesn't know how to feed his or her family, it is clear that the judiciary can't be independent. And we see in other countries that the judiciary is very badly financed, which leads to grievances. The legitimation by the sovereign, the people, is very important for Switzerland, and I think we will touch upon that in the second part. Thank you very much, Ms. Sanders. So we come to the conclusion of the first part of our conference, the European part. Like in a good seminar in Switzerland, I would say that the best seminars are the ones where we as lecturers learn the most. And I think it was a fantastical round. I learned a lot. It was very interesting. And it was impressive what we heard from you. I think in the second round, in the Swiss part, we're going to keep all what you said in mind. Thank you very much. I think we were able to answer some questions, not all of the questions. I also have some questions left, but I think that I'm sure that we will have a second conference of the kind, and we'll maybe touch upon these questions the next time. So now we have 15 minutes break, and we will find ourselves here again. Mr. Stadelmann will host that second part about Switzerland. Enjoy your coffee. Thank you very much.